The feds just won round 2 in court against the Missouri Second Amendment Preservation Act. This is a law which bans the state from helping enforce all kinds of federal gun control, past, present, and future. Now, here's the kicker. They didn't say that the act is unconstitutional for banning help in enforcement, for what it does. Instead, for the words it uses, for having the audacity to claim that a federal gun control measure might be invalid in the state of Missouri. So on this episode, I'm going to break down a little bit more about the law, what happened in the Eighth Circuit. I'm going to personally take responsibility for this setback, but we also have to share a very straightforward silver lining, a clear path to liberty going forward. But first of all, before getting to all that, welcome and thank you for joining me here on The Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Friday, August 30th, 2024. And let's kick it off with just a brief introduction to the Missouri Second Amendment Preservation Act in a report by Mike Meharry when it first went into effect in 2021. The law bans any entity or person, including any public officer or employee of the state and its political subdivisions, from enforcing any past, present, or future federal acts, laws, executive orders, administrative orders, rules, and regulations that infringe on the right to keep and bear arms. Now, in the Eighth Circuit, Chief Judge, Judge Colleton, I believe his name is, wrote a really brief opinion, very, very short. I think Jonathan Adler said it's just a shockingly short one. In this case of the United States versus Missouri, he was joined by Judges Loken and Kelly. I'm not familiar with any of them, but just like the district court held the opinion in early 2023, the Eighth Circuit recognized this, and here from the opinion: Missouri may lawfully withhold its assistance from federal law enforcement. Just very straightforward. That ban that passed into law, this judge, just like the previous one in early 2023, this is the second round, have both affirmed that Missouri may lawfully withhold its assistance from federal law enforcement. It says again, Missouri has the power to withhold state assistance. Straightforward. Now, this is, of course, for those of you who are familiar with this kind of stuff, based on the long-standing legal doctrine known as anti-commandeering. This is where the federal courts have held repeatedly in a bunch of major cases over 170 plus years that the federal government cannot require states to use or expend personnel or resources in any way to enforce or implement or effectuate federal acts or regulatory programs. I covered 5 of the main cases starting from 1842 with the most recent one in 2018. In an episode just earlier this month, States Can Check Federal Power, Anti-commandeering Explained. I urge you to check that one out so you have the framework, the legal framework for what this is all about. Now, that'll be linked to in the show notes. Alan Mosley does an awesome job getting that organized, and I will get that published a couple of hours after this live stream is done over at 10thamendmentcenter.com/path to liberty. Now, moving forward, we now have 2 more federal courts affirming that Missouri absolutely can, if she wants to, withhold assistance to enforcing federal gun control measures, really anything. But here's the reason why the DOJ is working to get this blocked. Even though they know that they can do this, they're looking for a loophole in the language of the legislation that can give them a little wiggle room to convince a court to shut it down. And that's exactly how it's been playing out. But they're working to get it blocked. Why? Because the law works. It has been very effective in regards to what the goal is. In other words, we don't like federal gun control and we don't want to see it enforced. And here from the opinion just this week, in 2022, the United States sued Missouri to enjoin implementation and enforcement of the act. The United States alleged that the act impeded the federal government's ability to enforce federal law by causing state officials to withdraw from joint task forces with federal law enforcement, which is exactly what happened, and that's exactly what the goal was. We wanted the state to stop helping enforce federal gun control. That means withdrawing from all these joint task forces that do that. Also, by disrupting information sharing between state and federal officers, and by causing confusion about the status of federal firearm regulations in the state. And they really, really pressed forward on the last one, at least in the case. Now, the DOJ actually affirmed this. They issued a press release in 2022 when they filed the lawsuit. And here from the title of it, Missouri House Bill 85, makes enforcement of federal firearms laws more difficult, thereby impeding law enforcement efforts to combat violent crime. Again, all the courts on the federal level agree that the federal government, Congress, the executive branch, none of them can require the state to actually help enforce federal gun control. And here's the complaint. The top part of the complaint is, well, they've done what we've all said that they can do, and now we're complaining that we're going to have a harder time enforcing stuff. The reality is the ATF doesn't have enough person power or resources to enforce all this stuff on its own, even with the help of the states. If you look through the statistics that the ATF releases year in and year out, they have somewhere around 5,100 employees, maybe 5,500 when it's really, really high up there, for the entire country. And about a third of them are in administration. So there's really only like 25 to 3,500 enforcement agents, and they can close only between 8,000 and 10,000 cases per year with help from the states. Just imagine if the states stop helping them out and there were, let's say, 10 or 11 or maybe 13 million undocumented short-barreled short-barreled rifles. I'm not sure the right term, short-barreled shotguns in violation of the NFA of 1934, which I would say shouldn't exist. There's no way that the federal government would have the ability to do anything about this. And they don't want this to get out of hand because it really, really works. Again, back to the DOJ press release. The complaint alleges that the restrictions imposed by HB 85 have hindered cooperation and other activities that assist federal, state, and local law enforcement efforts. That was the point. Federal law enforcement agencies within the state report that enforcement of federal firearms laws in Missouri has grown more difficult since HB 85 became effective. This should be a green light for us to push forward, but we do have to think about, well, how is this going to play out in the federal courts? And I'm going to point out how the federal courts have told us that they can get this done without having a problem there. The penalties here from the DOJ, the penalties associated with HB 85 have prompted state and local agencies and individuals within those entities to withdraw support for federal law enforcement efforts because there are significant penalties saying if you still participate anyways, we are going to go after the agencies for doing that. And so therefore, they're just like, oh, we're out of here, including by not sharing critical data used to solve violent crimes and withdrawing from federal joint task forces. That's basically the DOJ saying this works, so we got to find a way to get it shut down. Now, Ilya Soman, over at the Volokh Conspiracy, he pointed out, really interesting legal blogger here. Nonetheless, he said, the Eighth Circuit still struck down SAPA, the Second Amendment Preservation Act, because the state statute says that the federal laws it targets are invalid. While the state can refuse to help federal law enforcement, that, quote, does not mean that the state may do so by purporting to invalidate federal law. So on the one hand, they're saying, okay, you can absolutely do this if you want to. You don't even need a reason to do this. You can just choose not to because it is up to the sovereign people of the several states to determine how their resources are going to be spent by their state governments. And if the state governments say we're not going to spend resources to help the federal government, then they don't have to. But the problem that they're saying is also within the law, within the Second Amendment Preservation Act, is language that purports to invalidate federal law. I think they're wrong on that, but, well, this is how it's rolling. This reasoning, Ilya says, strikes me as wrong. Agreed. All SAPA actually does is deny state assistance to federal efforts to enforce certain gun laws. That is the operative action. The prohibition is on helping enforce. It uses language to explain why they've chosen to do this, because it is their view that these things are invalid, unconstitutional, in essence, infringements on the natural right of self-defense. The law does not impede, Soman writes, the federal government's own law enforcement efforts. It says we're withdrawing. Now, you ATF people, you figure out how to do this. And now they're telling us, well, we can't do it without your help. So we're going to try to get the courts to force you to do it anyways. Soman says the fact that the state's motive for denying assistance is a belief that the federal laws in question violate the Second Amendment and are therefore invalid should be immaterial. Now, here's the language used in the text of House Bill 85, SAPA, section, 1.430. Now, there's a lot of different sections. We got to be very grateful to people like Dave Rowland, Ron Calzone, and others who broke it down to different sections. This was an 8-year process to get this thing passed. It went through many iterations from early versions And it was a really good idea to do this because they included what's called a severability clause. That is, if something is seen as unconstitutional, you can just strike down that part of it, but the rest of the law stands. Now, they didn't do that, and Ilya talks about that in a bit as well. Here from the language, all federal acts, laws, executive orders, administrative orders, rules, and regulations that infringe on the people's right to keep and bear arms, as guaranteed by the Second Amendment to the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, shall be invalid to this state, shall not be recognized by this state, shall be specifically rejected by this state, and shall not be enforced by this state. So they're basically saying, like, we're looking at this stuff, and we here in Missouri, we're going to look at it as unconstitutional. I mean, you may think it's different. Now, the original language didn't say it like this. It didn't say to this state. It would say within this state. So I think that was a little bit more problematic, and they tried to make some changes to improve on that. But the federal courts still don't like it. Anyways, Soman goes further with this. He said, there are situations where an otherwise permissible state law becomes unconstitutional. Again, he's a constitutional scholar and a legal expert and a blogger on these types of issues. So he's arguing basically from the perspective of, well, how does it play out in the court system currently? How do the courts view it? And the courts currently view certain situations where an otherwise permissible state law becomes unconstitutional due to illicit motivations. Examples include if the law is motivated by racial or ethnic discrimination. He said, but a belief that a given federal law is unconstitutional isn't one of them. So what they're saying is you can't call a federal law unconstitutional. That's our job. You can't infringe on our space. He said that's true even if the state legislature is wrong to think the laws in question violate the Second Amendment or any federal clause or any amendment. He said even if these federal laws are perfectly constitutional, the state still has the constitutional authority to refuse to help enforce them. In short, whether it's the 170 plus years of opinions from the Supreme Court on the anti-commandeering doctrine saying that they don't have to help, or it's the expressly stated position of founders like James Madison, Roger Sherman, and others, or the third Chief Justice Oliver Ellsworth and many others, when a state uses the anti-commandeering doctrine, when they use this approach, it doesn't matter if the federal act in question is constitutional or not. That's because federal power under the constitutional system does not operate on the states. This was done intentionally. The Federalists told us over and over and over that they did not like the Articles of Confederation, and one of the big reasons why was if you wanted to effectuate something from Congress, like taxation, it relied on the states to take action to implement it. So they intentionally said, we're going to bypass the states, and the new proposed federal government will operate directly on the people, and we won't have to rely on the states. And Alexander Hamilton actually lamented. He complained about this whole process in Federalist number 16, and I'm just doing this off the top of my head here. But he basically said if the interposition of the state legislatures be necessary to give effect to a federal act, they only have to not act or act evasively, and the measure is defeated. So ultimately, as long as the federal government is relying on the states, we know that all they have to do is not act or act evasively, and they will defeat the measure. We see this playing out in practice with the Missouri Second Amendment Preservation Act, and the DOJ is complaining that that's working exactly how it's supposed to. Now, again, the federal law does not operate on state governments. And Oliver Ellsworth, the third Chief Justice, put it like this. This Constitution does not attempt to coerce sovereign bodies, states, in their political capacity. In those situations, the Supremacy Clause doesn't even apply. You don't even have to wonder if the federal act is constitutional or not, if there's a conflict, if there's supremacy, because the federal government has no authority whatsoever to commandeer the resources of the states. And I covered this whole process, 10th Amendment, why the Supremacy Clause doesn't apply when states opt out, to explain this kind of really weird kind of legal scenario. I covered that in an episode earlier this year that'll be linked to in the show notes as well. But moving forward, So the only way that they've been able to bring the supremacy clause into this opinion was due to what I'm going to call a very bad strategic error. I mean, hindsight is 20/20, certainly, but including in the language of the act a reference that federal acts are in essence unconstitutional by calling them invalid or infringements on the Second Amendment or part of the Missouri Constitution. And I'm the one that actually has to take the blame for this. I mentioned that right at the outset, but I personally take responsibility for this setback, for this language, more than anyone. Not only has the 10th Amendment Center as an organization, but myself personally, we've been involved in this effort pretty much since day one. For more than 12 years since we first started getting the ball rolling on the Missouri Second Amendment Preservation Act, and even before that. Now, we had our own model legislation, Second Amendment Preservation Act, that we released in December of 2012. And it used this kind of language referring to state or to federal acts as invalid in the state, not recognized by the state, etc. Very similar to what ended up in the final version of the Missouri Act. And we also use similar language in bills previous to that on other issues for a number of years. So without that language in there, the federal courts don't have a leg to stand on, and they know this. So by continually reaffirming that it's 100% constitutional for them to stop helping enforce federal gun control, we know that just having that language out of there, calling something an infringement or unconstitutional, means there is no case whatsoever. So I'm going to say it really is my fault more than anyone for really kind of starting this process as early as maybe 2008 or 9, having language and model legislation out there that use that type of phrasing. And I think that's really screwed things up and slowed things down for our movement. And anyways, if you want to learn a little bit more about this type of an effort, the history of these Second Amendment Preservation Acts, using the 10th Amendment to defend the Second Amendment. I did an episode on this over 3 years ago, a brief history of using the 10th to defend the Second. That'll be also linked to in the show notes. But a few years ago, we actually really started aggressively shifting our strategy in a number of other states with the thinking that, well, we're doing much better. We're going to get much better results if we can avoid landing in federal court. So if we use any kind of language that ends up in federal court, we know the federal courts are stacked against us. And there aren't too many people out there who are willing to say, well, what do you have to say about this? You may have an opinion, but kind of why don't you try and come and enforce it? We're going to do it our way anyways. We don't expect that. We would love to see that type of thing maybe one of these days. But I have no expectation of any state taking that kind of a stand, having that kind of backbone. So our strategy a few years ago really started shifting towards pushing away from that kind of language, not referring to something as unconstitutional, because it doesn't matter. If you can withdraw resources from enforcing it, we can call it unconstitutional on the side all day long. We don't even have to. We're just saying, you know what? If you guys want to try to pull this off, bring it. We're not going to help you, and you won't be able to enforce it because you don't have the resources, the manpower, the person power, the etc. And then we don't, on top of it, if you land in federal court, then you have to rely on federal judges to agree with you. And almost all of them are against us. There are very few, if any, that really are really solid on the original legal meaning of the Constitution. Now, of course, I agree with Ilya Soman on this, that the federal court is absurdly wrong on this for claiming that the motivation in the language of the legislation of the act, saying why they are doing this, I totally agree that that shouldn't be problematic. But unfortunately, the federal courts do not like this. The federal courts do what federal courts do. They generally protect federal power, especially their own. Now, Michael Ramsey over at the Originalism blog also takes a position on this. He said it shouldn't matter why the state decides to act as it does. That is, whether it thinks federal firearms laws are unconstitutional or just bad policy. As long as the state's actions themselves are constitutional, which they are. And Ramsey is one of the best originalist scholars out there. There are areas where I would disagree with him, but he's really, really, really good. And if he's saying, straight up, this is totally constitutional, the judges are telling us to withdraw support is constitutional, it's totally legal, they may do this. It's just that they referred to something as invalid and unconstitutional. Now, since setting that aside, And I think it's really important to point out that despite this setback, now 2 rounds in federal court, it's really an easy fix for Missouri if they want to going forward. If the next level of the courts disagree with us, and I'm starting to think that all the way up to the Supreme Court, we're going to get bad opinions on this. And if we do, the fix is very simple. Someone puts it like this. Oh, well, first, before getting to that, I think it's important to point out a couple of other flaws in the opinion that are worth mentioning. Here's how he put it. Another flaw in the Eighth Circuit decision is that it refuses to sever the part of SAPA it found unconstitutional from the rest of the statute, despite SAPA having an explicit severability clause. There is a clause in the act. Let's see if I can pull it up here. No, I don't have it handy. There's a specific clause that says if any part of this is held to be unconstitutional, the rest remains, and that part is severable. This is very common in legislation, especially in Missouri. They write here, we conclude that the law is not severable because the entire act is founded on the invalidity of federal law. And Ilya puts it like this. However, SAPA's statements of the reasons for the law, the invalidity of federal gun control, is severable from the operative portions of the statute which bar state officials from helping enforce federal laws in question. He says that he believes the Eighth Circuit, just like the district court back in early 2023, they also ignored Missouri's requirements that state laws be interpreted intentionally to avoid unconstitutionality. This is how you read the law in the state of Missouri. You have to interpret it in a way that avoids the unconstitutionality. Where possible, federal courts must defer to state courts in interpreting the state law. That's how it goes there. Here, he writes, that means that the declaration of invalidity should be interpreted as only extending to state assistance to the feds, not any general invalidity of the laws within Missouri's border. I actually disagree with that. I think he's taking it too far. I think they, in the legislation, because I wrote the one, maybe the original version or very close to it, the intention certainly was to say that the federal acts are invalid and unconstitutional. So we know that just get rid of that really is the way forward. Now, back to the opinion. Here's another major flaw in the opinion. This is what they say. The Supremacy Clause states that federal law is the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. This is the Supremacy Clause by the Article 6, Clause 2. By this declaration, the states are prohibited from passing any acts which shall be repugnant to a law of the United States, McCulloch versus Maryland. For those of you who are, constitutionally literate, you are very familiar with what was skipped intentionally by this judge. It's just patently false. I see it as a lie by omission, and I think the judge has to know it because they cited part of the Supremacy Clause, but omitted the most important part. And Michael Ramsey put it like this. The first sentence, though, is not correct. It's just false. The Supremacy Clause states that federal laws made in pursuance of the Constitution are the supreme law of the land, and anything in the Constitution or laws of any state to the contrary notwithstanding. So you can see here, if you're looking up on the screen, literally in the federal court opinion, the Supremacy Clause states that federal law is the supreme law of the land, period. Not with the caveat that they have to be in pursuance of the Constitution. So here we are, another federal court unanimously just butchering the Supremacy Clause to fit its own narrative. Anyways, Ramsey goes on with this. Federal laws not passed in pursuance of the Constitution, that is, unconstitutional acts, are not the supreme law of the land. And he cites Hamilton's discussion in Federalist 34, noting that Article 6 expressly confines the supremacy to laws made pursuant to the Constitution. And then he said the second phrase is only right, citing McCulloch, is only right if one reads it to say the states are prohibited from passing any acts which shall be repugnant to a constitutional law of the United States. So this is very distorted stuff. It doesn't really impact the strategy going forward, because either we're going to wait and see if maybe a higher court says, okay, it's okay for them to call something invalid, or they're going to tell us, no, never can you ever say something is unconstitutional and put it into state law. And while we will disagree with that and we will try to fight to have that changed, if we really want to end enforcement of federal gun control, we'll just remove that language from the legislation. And hopefully the people in Missouri can just quickly do an amendment and change that legislation, remove it. I'm not sure what the process is, to be honest with you, but to be effective, and we know the DOJ is telling us that this strategy is incredibly effective, we got to just do what we got to do with what we got. And I think Soman does a great job of explaining this path forward. He says, despite these flaws from the Eighth Circuit opinion, he said the Eighth Circuit ruling, I hate calling it a ruling, actually provides a roadmap for how Missouri can easily fix the Second Amendment Preservation Act and protect it against future legal challenges. It could bar state officials from helping to enforce the exact same federal laws, but do so without asserting that the laws are invalid. Straightforward, so easy. We've got it all there on paper in 2 federal court cases on this particular state law. He said, substantively, this revised SAPA would be exactly the same as the current version. But by avoiding references to these dangerous terms of invalidity, and that was my take on it, the state can satisfy the test set up by the Eighth Circuit. After all, the court concedes, as it must, that Missouri has a right to, quote, withhold its assistance from federal law enforcement. And that's exactly what we have been pushing for and supporting in other states. I mentioned we've kind of shifted our strategy in recent years, and we've seen this, and we've been on board helping and supporting and working with efforts in Arizona, Montana, and elsewhere to withdraw support for enforcing some federal gun control, or sometimes all of it, without calling the federal acts in question unconstitutional in the law. And that way it doesn't offend the insecurities of these arrogant federal judges for the empire. And it has played out exactly how Ilya Soman told us it would. The state withdraws support. The feds do nothing about it because they can't do anything about it. So here is one example. In early 2023, the governor of Montana informed the Attorney General of the United States that, quote, as a matter of law, the state of Montana and its political subdivisions cannot enforce or assist the ATF with enforcement of this rule. So they're referencing a particular rule from the ATF. There is a state law that was passed thanks to the great work of Gary Marbut and others in Montana, the Montana Shooting Sports Association, MTSSA. I always get it wrong. But they did amazing work on getting this passed, getting something moving forward. And it said that they're not going to enforce certain federal acts. And they did not refer to any of them as invalid or unconstitutional. And what happened? So when the ATF tried to implement something that was included in the state law, the governor just sent a letter saying, we're not going to help because our law says we're not going to be able to do that. We're banned from doing that. There was no lawsuit, no threats of funding taken away, no nothing. That's because when you use this approach and you use it in a really smart way, the feds have nothing to stand on. And that's why we have published a version of this quote that's up on the screen I did a quick search on the back end of our website as I was organizing my notes for this, and it came up with 297. We'll go with 300 times on the 10thamendmentcenter.com website since early 2016 when we started pushing in this direction. This is what it says. No determination of constitutionality is necessary to invoke the anti-commandeering doctrine. State and local governments can refuse to enforce federal laws or implement federal programs, whether they are constitutional or not. That's the more recent take on this. We've had other versions of this hundreds of times now over the last number of years since early 2016, pushing this. And the message should be very straightforward. Refuse to comply and nullify. And we've got to get this message out to a lot more people because so many people are ignorant of how this all plays out. The government-run school system, of course, teaches us that the only way to stop the federal government is to basically beg the federal government to limit its own power. And what has been the result? Government keeps growing and growing and growing. Unconstitutional, invalid federal gun control measures have been on the books for almost a century. We're talking about the NFA of 1934, the Gun Control Act of 1968, its amendments in 1986, the Undetectable Firearms Act of 1988. Of course, we had the bump stock ban. Well, that's a little different now, and everything else since then. There was another one, the Safer Communities Act. All this stuff has been unconstitutional and invalid and an infringement on the natural right of self-defense since day one. But the federal government will not stop itself. That's why it's essential, as the founders told us, for the states and the people to get the job done, as James Madison put it in Federalist 46, a refusal to cooperate with officers of the Union. And nothing helps us do this kind of work, get the job done day in and day out, more than the financial faith and support of our members. You can join us for as little as $2 a month over at 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. I'd be incredibly grateful for any consideration you can give to joining us today. Of course, you can also help us spread the word a few free and easy peasy ways as well. Smash the like button, subscribe, get notifications, comments, especially in the archive, leaving reviews on Apple Podcasts or any other podcast platform. All that stuff can help trigger the algorithms, especially of the mainstream platforms, and tell them to show us to more people. Again, I really appreciate you spending some of your time with me today. I will be off on Monday, but back to my regular schedule after that. I hope you enjoyed this episode. I hope you learned something that's more important than anything. I hope you have an awesome weekend, and I look forward to seeing you next week here on the Path to Liberty.